Morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what we call an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a misdemeanor case. It is a criminal case, and criminal cases are divided into felonies or misdemeanors. Your felony cases are your most serious type of offenses, whereas your misdemeanor cases are referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, the first case that I'm going to call is Michaela Leanne Jackson. Ms. Jackson, would you please come forward? Ms. Jackson, your full name is Michaela Leanne Jackson?
Yes, sir.
How are you doing, Ms. Jackson?
Fine.
I'm doing fine. Thanks for asking. Ms. Jackson, you're represented in your cases by your attorney John Macy. Attorney Macy, how are you doing?
I'm fine, Your Honor. Thanks for asking.
You're welcome. And the state is represented in these cases by attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, and yourself?
I'm doing fine. Thanks for asking. Now, Mr. Macy, what is your announcement in Ms. Jackson's cases?
Your Honor, I'm still, there's still some unresolved. I'm trying to get, work out whether or not we can dispose of this case with, Mr. Hubel. I asked for one reset, allow him to do some things and me, to try to, after he does that, for me to negotiate with him if possible.
Okay, I'm gonna put this on the pretrial. Let me see. Yeah, I'm gonna put this on the pretrial docket. Give us a reset date. Okay, this case will be reset. Well, these cases will be reset to October 28th of 2024. Ms. Jackson, you're going to get your resets from your attorney. Once you get your resets from your attorney, you'll be free to go. Oh, you're checking his date?
If you don't mind, Judge. Oh, no, that's November. Thanksgiving. October 20th. Looks like that's perfectly fine.
Okay.
Yeah.
So, Ms. Jackson's, your cases will be reset to October 28th, 2024. Once you get your resets from your attorney, you'll be free to go and you have a blessed day. And Mr. Macy, I'll see you this afternoon for trial at one.
Yes, I'll be here.
All right.
Thank you.
Okay. Now, ladies and gentlemen, as I was mentioning, your case is a misdemeanor case. It's a criminal case, and criminal cases are divided into felonies and misdemeanors. Your felony cases are commonly referred to as your most serious type offenses, whereas your misdemeanor cases are referred to as your petty offenses. And what that means, it just simply means that the misdemeanor cases are not as serious as a felony offense. Do we need an interpreter? Ms. Bailey, do we need an?
I gave the Spanish to him, so they're going over it with him.
Okay.
You want to hire him?
Normally, we have our interpreter to go over the paperwork with him because some legal terminology that they may not understand.
They were just helping them fill this out. However you want me to do it.
Yeah, but you're still gonna have to have,
Right.
yeah, because right now they're making some noise and it's kind of distracting. So let's see if we can get Ms. Araji.
Right now or when you get done. I'll call it, just give me 1 second.
Yeah, okay. Okay, so at this time, ladies and gentlemen, as I was mentioning, your case is a misdemeanor case, and it is a criminal case. Um, Cases are divided into felonies and misdemeanors. Your felony cases are your more serious type of offenses, whereas your misdemeanor offenses are normally referred to as your petty offense. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, felonies, and when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Your felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if we had a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If you have a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years, and a fine in 10 years in the state penitentiary, and a fine that does not exceed $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum. Okay, everyone in court, if you have a phone, turn your phones off. Okay? Everyone, please turn your phone off on silent. Okay, now if you have a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine of $10,000. Or if you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine up to $10,000. If a person is convicted of a capital murder, which is the highest felony, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, the case that you have in this court is a misdemeanor case. So therefore, you don't have to worry about the felony punishment. Now, your misdemeanors are divided into 3 categories. We'll start at the top and work our way on down to the bottom. We have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is a fine that does not exceed $500. The gentleman that speaks Spanish, would he come on up? Now have a seat at that table. Need to go over the paperwork.
Okay.
And if a person is convicted of a Class C misdemeanor, as I was saying, it's by fine only. You cannot be given jail time. So the fine is anywhere from $0 to $500. And if, however, if the person fails to pay the fine, or if the fine is converted to community service and they fail to perform the community service, then the court can issue what is called a capias pro fine. And with the capias pro fine, that simply means that the court can issue a warrant for your arrest to either pay the fine or sit the fine out in the county jail. And now, if a person has a Class B misdemeanor, which is the next highest misdemeanor, the range of punishment is minimum 0 days to 180 days in the county jail, and a fine that does not exceed $2,000, or a fine that does not exceed $2,000, or the person can be given both such fine and confinement. Now, if a person is convicted of the highest misdemeanor, which is a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. So you have unadjudicated probation or adjudicated probation. And the difference between the two are as follows. With adjudicated probation, it does result in a conviction on your record. And however, there's something that is called judicial clemency, which means that if you successfully complete the probation, the adjudicated probation, the court can set aside your conviction. That means you will no longer have a conviction. In order to qualify for that, three things has to happen. One, you have to successfully complete the probation. There cannot be any more time left on the probation, and you have to be successfully discharged off of the probation. If those three things happen, then the court has the discretion to set aside the conviction and grant you what is called judicial clemency. And you will not have a conviction on your record. However, if you get another conviction later on, we call it a subsequent conviction, then the case that you received judicial clemency on can be brought back up. It could be resurrected, revived, or brought back up, and it could be used against you. And if you try to get a license with CPS, which is Child Protective Services, they can deny giving you a license. Or if you have a license, they can suspend or revoke your license. Now, the other type of probation is called unadjudicated probation. With unadjudicated probation, once you're placed on probation, you do not have a conviction on your record. And if you successfully complete the probation, you will not have a conviction on your record. And you may qualify for what is called a non-disclosure. A non-disclosure means that the court cannot disclose the fact to the general public that you were on deferred probation. So the court, the government, we can't disclose the fact that you were on deferred probation to the general public. Now, the term I used was general public. That simply means that the government can have access to it. But most of the public is general public, so most of the public will not have access to your record if you get a non-disclosure. And a non-disclosure basically means that your record is sealed to the general public. Now, next, now you have the option today to enter one of three types of pleas. You can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you could enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting the charges or you will not be contesting the charges. Or you could enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. So you can enter a plea of not guilty, guilty, or no contest. Now, as a defendant in a criminal case, you have rights. And we're going to talk about some of the rights that you have as a defendant in a criminal case. The first right that I'm going to talk about is your right to have an attorney. Now, on the paperwork that has been handed out on the clipboard, I'm going to go over that paperwork with you. The first document that we're going to go over is titled Judge's Explanation of Rights to Defendants Without Attorney. Okay? Make sure everyone has that document. Make sure everyone have that document. Okay, I'm getting ready to go over this document with you. And it states as follows. As a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date. That basically means that your case will be rescheduled to give you time to hire an attorney. Now, if you want an attorney, but you do not have enough money to hire an attorney, then you can request that an attorney be appointed to represent you. And then the proper person will determine whether or not you qualify for an attorney. But you must first fill out what is called a financial questionnaire. The financial questionnaire is a document on that clipboard that is titled Jefferson County Affidavit of Indigence. For those individuals who will be requesting a court-appointed attorney, you have to fill out the first page of that document and half of the second page. All right. Now, going back to the first document, judge's explanation of rights to defendants without an attorney. Now, if you want to represent yourself, you may not speak to the prosecutor unless you first sign a written waiver of your right to be represented by an attorney. The written waiver is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, that document will be signed only by individuals who will be desiring to represent themselves. If you don't want to represent yourself, you don't have to sign that document. If you do not want a court-appointed attorney, you do not have to sign the affidavit of indigence. If you just want to represent, if you want to hire an attorney, you'll just sign this first document that says judge's explanation. Only one document. Okay. Now, for those individuals who will be asking to represent themselves, that is, giving up their right to have an attorney and represent themselves, on this first document that is titled Judge's Explanation of Rights to Defendants Without an Attorney, the fourth paragraph states, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, that is, waive your right to an attorney and represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Do you understand that? Okay. Now, at the bottom of this document, you will have to put your initials and signature initials on the appropriate line. It says, defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to ask for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to represent yourself, that is, to waive your right to an attorney and to represent yourself, then you will place your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date. And today's date is September 24th of 2024. Now, for those individuals who will be representing themselves, they will have an opportunity to talk to the prosecutor who is sitting at the table before you in the blue suit. Because the reason why you'll have opportunity to talk to him about your case, because at that point, you'll be representing yourself. In essence, you'll be acting as your own attorney. All right. Now, for those individuals who will be waiving their right to an attorney, you'd have to read and sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And I'm going to go over this document with you right now. And it states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Voluntarily means that I know what I'm doing, intelligently being made. Well, voluntarily actually states that no one has forced me to enter this plea. I'm doing it of my own free will. And intelligently made means that I know what I'm doing. Furthermore, I have been advised this 24th day of September 2024 by County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that is your choice, then you'll sign your name on the line that's titled defendant and you was dated today's date. Now, for those individuals who will be requesting a court-appointed attorney, we'll turn to the document that is titled Jefferson County Affidavit of Indigence. And on that document, at the top, it has information as your name, your first name, middle initial, last name. You'll fill that out, your date of birth. Then we'll go down to your address. You'll fill that out. And then your phone number, a home, cell, work, or family member. And then the next line states, if you receive any of these benefits, then you will mark the box of the benefit that you receive. Medicaid, SSI, SNAP, TANF, or public housing. Are you employed? If yes, you check yes. If no, you check no. Now, if you check yes, you're gonna say where and what type of work you do. And then the number of hours on the next line per week you work and how long you work at this job. And the next line asks for your marital status, whether or not you're single, married, divorced, widowed, or separated. And if you're married, you're gonna write your spouse's name and the middle initial and last name. Now, if you have any children 18 years old or younger, then you write their names and ages on the next set of lines. And then when we get to residence information, it says whether or not you rent, own, reside with a family member, or you're homeless, and you're gonna check the box where it's appropriate. If you reside with someone, a family member, you're gonna check yes. If you're homeless, you're gonna check yes. Or if you own your home, you circle yes. And if you rent, you circle yes. Now, below that, on the left side, it states monthly income. Your monthly income, that is what you take home. If for those individuals who are working. Now, if you have a job and you have an income, you're gonna say what you take home a month. If you do not work, it's gonna be zero. If you have a spouse and they work, then you put their monthly income. If they don't work, it's zero. If you don't have a spouse, it's zero. If you receive child support, if you put that amount per month. If not, zero. If you receive food stamps, that monthly amount. If not, zero. Social Security, you put that amount. If not, zero. Other government checks, you put that amount or zero. And other income that you may have, some people may work more than one job. If not, zero. Then your assets, if you own a car, house, etc., you put what the assets is, I guess what it's worth. And then you're gonna total everything in that column, add it up and total. Now we go to the right side of the document, it says monthly expenses. If you're paying rent or mortgage, you're gonna put what you're paying per month. If you have utilities, light, gas, water, you're gonna add those up and put that amount in there. And if you have total child expenses, if you paying child support, and are you paying for other things for your children, you add that up together and put that amount there. Your food expenses for your household, your transportation costs, that's whether or not you have gas, car note, car insurance, add all of that up. If you have a cell phone bill or home phone, you're gonna put that on the next line. Probation fees, that's probation, parole. If you have bondsman, paying a bondsman, put that on there. Your medical expenses, or if you have health insurance, you're gonna put that amount. And then if you have a credit card, what is your minimum payment? And then you're gonna add everything in that column and you're gonna total it. And then once you go to the next page, it says defendant's oath at the top. You're gonna read and sign where it says defendant's oath. You're gonna fill in today's date, the 24th day of September, 2024. You're gonna read that information that says, I have been advised of my right to representation by counsel in connection with the charge pending against me. I certify that I am without means to employ counsel any of my own choosing, and I hereby request the court to appoint counsel for me. And then you will sign your name on the line that's titled defendant's signature, dated today's date, September 24th, 2024. And then we go down to the next section where it says, you're gonna skip administered oath, you're gonna go to unsworn declaration by defendant, and it says defendant only. You're gonna place your name, your date of birth, your address, and the country is USA. And it says, I declare under penalty of perjury that the foregoing is true and correct, executed in Jefferson County, state of Texas, on the 24th day of the month is September, the year is 2024. And that you stop right there. And that bottom portion and the third page will be for the court, the judge to fill out. Now, that's basically that's the information that we have regarding your right to have an attorney. Now, as a defendant in a criminal case, you also have a right to have a jury trial. There are 12 chairs over there to my left. That's called the jury box. 6 citizens from Jefferson County will be selected to sit or to serve as jurors in your case. They will listen to all the evidence, listen to the arguments of the attorneys, and then they will decide to, after they deliberate, to find you not guilty or guilty of your charge. You also have a right to waive or give up your right to have a jury trial. If you waive or give up your right to have a jury trial, that simply means that you will not be having a jury trial, and your case will come before the court or the judge in one of 3 ways. It can come before the judge by way of a trial. And we call that a bench trial. It's a trial by judge only, where the judge will be the judge and the jury in the case. The judge will listen to all of the evidence. The judge will listen to all of the arguments. After listening to all of the evidence and the arguments, the judge will apply the facts to the law, or the law to the facts of the case, and then the judge will decide to find you not guilty or guilty. Now, you also, your case can come before the judge. Also, you also have a right to waive or give up your right to have a trial by judge. Just like you can waive or give up your right to have a trial by jury, you can waive or give up the right to have a trial by judge. Now, if you do so, that simply means that you're telling the court that you want a jury trial and you want to enter a plea of either guilty or no contest. And then the case will come before the judge by way of a plea bargain. What a plea bargain is, it means that you and the state have reached a settlement on your case. In essence, you settled your case, and that's what you call a plea bargain, when you and the state negotiate a settlement on your case. Now, if you're able to agree to a plea bargain, we call that an agreed plea bargain. That case will come before the judge, and the judge can do one of 2 things. The judge can accept or reject the agreement. If the judge rejects your agreement that you work out with the state, the plea bargain agreement, then you can withdraw your plea. In essence, if you say that, well, judge, I plead guilty to this charge, me and the state has a plea bargain agreement, the judge said, well, I'm not going to follow the plea bargain agreement. Well, you say, well, judge, I take my plea guilty back. You can do that. You can withdraw it. Now, if the judge does follow the plea bargaining agreement, and if you decide that you want to appeal your case, appealing your case means that you want to have a higher court than this court to look at your case to see whether or not this court committed an error by convicting you, or this court wrongfully convicted you, then you have to get permission from the judge to appeal your case. And if the judge gives you that permission, your case will leave this court and will go upstairs to the Ninth Court of Appeals. And those judges up there will review your case and they'll decide whether or not to grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty because they believe you might have been wrongfully convicted or this court committed an error by convicting you. Or they can send the case back down to this court and order this court to give you a whole new trial. Or now, if they reject your appeal, then you can appeal it to a higher court than them. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals in Austin, Texas. And you will have to file what is called a pro se. Pro se means you representing yourself. A pro se petition for discretionary review. So you'll be petitioning the Texas Court of Criminal Appeals to review your case to see if your appeal should have been granted, or to see if we wrongfully convicted you, or we committed an error by convicting you. Now, they can do one or two things. They can accept or reject that means they can either grant or deny your pro se petition for discretionary review. Now, if they grant your pro se petition for discretionary review, they can simply find you not guilty. Or they can order this case to go back to the Ninth Court of Appeals with instructions, or they can order it to come back down to this court and order this court to give you a whole new trial. Now, if they deny your pro se petition for discretionary review, then at that point, your conviction will stand. Now, you also have a right to have, if you and the state cannot come to an agreement on your case, and you would like the judge to decide what your punishment is going to be, we call that an unagreed plea bargain agreement. It's unagreed. And the judge can set your punishment anywhere within the punishment range for the offense. Now, you also have a right to have witnesses to come to court. Witnesses are individuals who can testify. They testify in that chair over there where the microphone is. We call that the witness stand. Now, what witness can do, they can testify for you or against you. And you have a right to call witnesses. You also have a right to waive your right to call witnesses. Now, let me back up. Now, if you do call witnesses, you have an opportunity to ask them questions, or your attorney can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses, and it means that you have a right not to call witnesses. Now, if you do not call witnesses, it does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have a right, it's called the Fifth Amendment right against self-incrimination. I know a lot of times we look at a lot of law programs on television and we see people saying, well, police go up to them and say, well, I take the Fifth. And what they mean by that is I'm exercising my Fifth Amendment right against self-incrimination. I have a right you have a right not to say anything. And so the government, the state, or the district attorney's office cannot force you to testify if you exercise or invoke your Fifth Amendment right against self-incrimination. Now, you can waive or give it up. And if you waive or give up your Fifth Amendment right against self-incrimination, that means that you will be testifying in your case against you. Now, you also have a right to have what is called discovery. Discovery means you have a right to see the evidence, have access to the evidence that the state has against you. Now, that means you have a right to see your statements, witness statements, police reports, lab reports. You have a right to see photos, video recordings, listen to audio recordings, have access to instruments or any type of document that they will be using against you in your case. Now, you also have a right to waive or give up your right to discovery. And by doing so, you will not be having access to the evidence that the state will be using against you. Now everyone that's here this morning for arraignment, you've been arrested. That means you've been arrested, you've placed in the county jail, and you're out of jail on bond. You're either out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you're out of jail on a PR or a personal recognizance bond, which means that you were released without paying any money. You was released under your own personal recognizance with a promise to appear here in court today. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail and then you bonded out. You and the state has come to a plea bargain agreement, and the agreement is that you serve 5 days in jail. That simply means you would not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail, you serve 5 days in jail, that means that you will only have to serve 2 days in jail because we will subtract the 5 from the 7, and that leaves 2. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. You are credited $100 per day for every day that you spent in jail that will go towards your fine and court costs. So, in using the same example, you spent 5 days in jail, that's $500 that can be used towards your fine and court costs. So if the state and you've reached an agreement for you to pay fine and court costs of $500, you won't have to pay anything. Why? Because you spent 5 days in jail, and the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if the state is offering fine and court costs of $700 and you spent 5 days in jail, that means you would only have to pay $200 because you already have $500 credit. We're gonna subtract the 500 from the 200, and at least, the 500 from the 700, and that leaves $200 that you'd have to pay on the day that you enter your plea, or the day that your case is disposed of. Now, if you cannot pay the $200 on the day that your case is disposed of, we can put you on a payment plan. That means you can pay so much every month until the balance of $200 is paid off. Now, some individuals may not have the income or may not have employment to pay off the $200. Even if we put them on a payment plan, no problem, because we can convert the fine and court costs to community service. You will receive $12.50 for every 1 hour, $12.50 for every 1 hour of community service that you perform. That $12.50 will go toward paying your fine and court costs. So if you work 8 hours one day, that's $100 that will go toward your fine and court costs. So in our scenario, you would have to work 2 days, 8 hours a day, and that will pay off the $200. Now, Jefferson County has a program for individuals who've never been in trouble. They will dismiss your case and you can get it wiped off your record. And in order to qualify for that program, it has to be your first time getting in trouble. It cannot be an offense for unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you at filling out and submitting the application to the district attorney's office. Now, Jefferson County has another program for veterans. It's called Veterans Court, for veterans only. If you are a veteran of any one of the branches of the United States military, with that program, it basically will do almost the same thing that pretrial diversion will do. That is, you participate in the program, then they will dismiss your case, and you can get a non-disclosure. A non-disclosure basically means your record is sealed to the general public. Now, if you're interested in any one of those programs, just let us know. And just let us know, and we'll have someone to talk to you about getting into those programs. Now, this court has a program that is called the Community Safety Initiative. It's a program that I started within the first 100 days of taking office. I started the program in March of 2017, and the program basically is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And the way we address this program, the way we address recidivism is through various partnerships that we have with certain agencies in our community. We have a partnership with Spindletop. Spindletop has a program, Spindletop is our local mental health program, and they're in the Southeast Texas region. And what Spindletop will do, Spindletop will be able to give you a private interview in our jury room or at their facilities or by telephone. They also have the ability to do an assessment, develop a treatment plan for either outpatient or inpatient treatment. Now, in order to participate in the program, you do not have to be incompetent or insane. You can just merely suffer from depression or anxiety or any other host of mental illnesses. And Spindletop has the expertise to address your mental health needs. Now, Spindletop also has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. And we also have a partnership with the Golden Triangle. We also have a partnership with our local Drug and Alcohol Council, and they have a program that is called OZAR. OZAR stands for, it's OSAR, which stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs for individuals who have issues with drugs and alcohol. And they will do a screening, an assessment, and they can refer you for either outpatient or inpatient treatment to address your drug and alcohol issues. Now, if you are unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you are trained in any one of those areas that you select, then they will assist you at getting a job in the area that you're trained in. Now, if you have not received, if you have not graduated from high school, received a GED, which is a graduate equivalency diploma, then CICE also has a GED program, which you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free, does not cost you one penny, it does not cost you anything. Only thing it will cost you is some time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just simply arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people, because we believe that productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2, we do not have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we also trying to, and if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I just mentioned, just let me know. The other the good thing about the program is that all these programs that I just mentioned can also be used as community service. So for example, you will ordered to pay a fine and court costs, but you can't pay the fine and court costs. We converted it to community service. So every 1 hour that you're working on your GED, if you're trying to get your GED, or every 1 hour that you're in job training, job placement program, or every 1 hour that you're in the Spindletop mental health program, or the ATOL or the Ozark program, every 1 hour that you spend in any one of these programs, $12.50 will go toward payment of your fine, 1 hour will go toward community service. And then the other point is that you're in the program. So instead of killing 2 birds with 1 stone, you're killing 3 birds with 1 stone. And that simply means that you're doing one thing, but you're getting credit for 3. So if you're interested in these programs, and as I mentioned, all these programs are free, does not cost you anything but time. And like my dad used to always say, I got more time than I have money. And so if you're like me, you should have the time and take the time to improve your situation. Now, at this time, we have some individuals from Spindletop who's going to come forward, and they're going to tell you more about the program that they have to offer at Spindletop. And Deputy Henry.
Morning. I'm Steve Henn. I'm a mental health deputy licensed by the state commission here with the sheriff's office. I'm here with my coworker Laurie. Now, Laurie is a mental health professional. The reason we are both here this morning, this courtroom, he does give every single person. The judge found that it's been proved that those who have really commonly have mental health needs, such as use disorders, or sometimes just like a community.
Good morning, my name is Lori Chapman, and like Secretary said, I'm a mental health professional with Spindletop Center. We are a mental health services provider, but that's not all we do. We are a community resource connector. That means if you have needs, we can help you meet those needs. All you gotta do is give us permission to reach out to you. We'll reach out to you and see how we can help.
Maybe this is your first time to be in court, could be your 5th time to be in court, there's still hope. In fact, what we're offering today has the ability to change your life. We're gonna need something from you. We're gonna need you to share that need with us. And Laura explained exactly how you can do that with that document that you was handed when you came to the door today.
What you're holding is an optional HIPAA compliant form. That means you don't have to fill it out if you don't want to. And also, if you do fill it out, it is completely private. The only people who see that form is deputy and our community. That way, your information is protected, and that conversation happens between you and me or another.
Also have this card that I want to give everyone today before you leave. It has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number, get help immediately. And it's going to be one of the first resources we can actually provide you here today. And just shortly, the court's going to go into recess. And when it does, we'll be able to come out there. We'll visit with you. We'll pick up those documents from those who want to turn them in. I'll be handing this out to anyone who would like to have one as well. And we'll be able to visit with you at that time in more detail. Thank you very much for your kindness. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Laura. Now, ladies and gentlemen, the paperwork that you have in your hand on the clipboard, we're going to pick that paperwork up from you. Make sure that is filled out. If you need help filling out the paperwork, we have our court personnel who's here who will be happy to help you fill out that paperwork. Now, once the paperwork is picked up, we're going to go through the paperwork and then we're going to call you up to the bench one at a time. Now, that's going to take us a little time to do. If you need to use the restroom, in the hallway, there are 2 restrooms near this courtroom. The men's restroom is right in front of County Court Law number 3. And on the opposite side of the hall is the women's restroom in the front of the 172nd District Court. And as I mentioned, you'll be allowed to go out and use the restrooms in the hallway. Now, do not leave the courthouse. If you leave the courthouse and your name is called and you do not answer, then your bond can be forfeited and a warrant can be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. So at this time, we're going to go into recess. And as I mentioned earlier, if you need any assistance with filling out the paperwork, please raise your hand so that our court personnel will be able to come out and help you. So at this time, the court will be in recess. Now, let me tell you this here, while we're in recess, That does not mean that, you can talk all loud or anything like that. We are still in court. Okay? And so, and as well, now Deputy Hinton and Lori is also gonna come out and visit with you. So at this time, the court will be in recess. Jefferson County Court at Law number 2 is back in session. Court is in session with the arraignment docket. First case that we have is cause number 24CCCRO 1968, case of style of state of Texas versus Kayla Marche Davis. Ms. Davis, is that your full name? Ms. Davis, would you please raise your right hand? Ms. Davis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Ms. Davis, you may put your hand down. How are you doing, Ms. Davis? That's good, Ms. Davis. You're represented in your case by your attorney, Attorney Jennifer DeLodge. Ms. DeLodge, how are you doing?
Fantastic, Judge. How about you?
I'm doing fine. Thanks for asking. Mr. Lodge, do you waive a record in Ms. Davis's case?
Yes, Your Honor.
And the state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Still doing well, Judge. Thank you.
That's good. Ms. Davis, I have before me on my computer a document that is titled Information. This information is filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Kayla Marche Davis, on or about July 9th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify a fugitive with intent to give false information. Ms. Davis, do you understand what you've been charged with? And to this charge, Ms. Davis, how do you plead? Guilty, not guilty, or no contest?
No.
Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Davis, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document? On page 2 of the same document, there's a set of initials on a line next to a box that's checked nola contendere, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that's titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Ms. Davis, before you sign and initial all these documents that I just showed you, did your attorney, Mr. Lodge, go over these documents with you?
Yes, she did.
And did you understand everything that Mr. Lodge went over? And is everything in these documents true and correct to the best of your knowledge? Ms. Davis, are you a citizen of the United States?
Silver States 1.
Any objections?
No objection.
No objection. State's Exhibit number 1 will be admitted. Mr. Lodge, you've advised in counsel, Ms. Davis. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Davis, your attorney, Mr. Lodge, has advised and counseled you. Are you satisfied with her representation?
Yes, I am.
Has she provided fully effective and competent legal representation?
Yes, she has.
Ms. Davis, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
For defense plea of no contest, the state has offered 78 days time served, short call tax and retired.
Ms. Davis, the state is offering that you serve 78 days in Jefferson County Jail. However, you not have to serve any more time in the Jefferson County Jail because you've already served 78 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Davis, do you understand the state's offer?
Yes, I do.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Ms. Davis, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Davis, if you do not have anything else holding you in jail, you should be getting out of jail today. Ms. Davis, please stand at the end of that counter. Follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go and you have a blessed day. And Mr. Lodge, you are also free to go and you have a blessed day as well.
Thank you, Your Honor.
You're welcome. Okay.
Thank you.
Next case is Byron Keith McCartney. Mr. McCartney, your full name is Byron Keith McCartney.
Yes.
Mr. McCartney, now, before we get started, you have a right to have a record of this proceeding. That simply means you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes.
Okay, now, Ms. McCartney, would you please raise your right hand? Mr. McCartney, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. McCartney, you may put your hand down. How are you doing, Mr. McCartney? I'm doing fine, thanks for asking. Mr. McCartney, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for purpose of entering a guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. McCartney, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. McCartney, I also have before me a document that is titled where is it? Okay, I have a document that is titled Information. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that on or about October 5th, 2023, while you were in Jefferson County, Texas, that you committed to Class B misdemeanor offensive criminal trespass. Mr. McCarthy, do you understand what you've been charged with?
Sir.
And to this charge, Mr. McCartney, how do you plead guilty, not guilty, no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay, Mr. McCartney, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. First set of initials is on the line that's next to the box that's check guilty. Did you place your initials VM on this document?
Yes, sir.
Second set of initials is below a paragraph that is titled Discovery Admonishment, and it is on a line next to a statement that reads as follows. I do not request discovery of evidence. I've waived my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document. And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this box, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement? Now, Mr. McCartney, before you signed and initialed these documents, did you read these documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. McCartney, are you a citizen of the United States?
Yes, sir.
Except for stage one.
Now, Mr. McCartney, the state is offering State's Exhibit number 1 to be used as evidence in this case. Now, State's Exhibit 1 is the first document that I showed you on this tablet. This is the same document that have your initials in the two locations that I previously mentioned and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay. No objection. State's Exhibit number 1 will be admitted. Mr. McCartney, is there any evidence that you're currently mentally incompetent to stand trial? Okay, Mr. McCartney, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Okay. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
That agreement is to 1 year deferred probation with a $300 fine, 24 hours community service and the requirement that the defendant stay off of Lamar University property.
What is the support cost? Oh, I need to talk to you about that. Let's see. That's 300, that's 1492. Okay. Now, Mr. McCartney, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. You'll also be required to pay a probation fee of $60 a month, your analysis fee of $15 and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $136 a month. Will you be able to pay the $136 each month?
Yes, sir.
You'll also be required to perform 24 hours of community service, and you cannot go on any Lamar University property. And you will also be required to adhere to the other standard terms and conditions of this probation. Now, Mr. McCartney, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Mr. McCartney, I follow the plea bargaining agreement that you have entered into with the state. Mr. McCartney, if you successfully complete this probation, you will not have a conviction on your record, and you may qualify for non-disclosure. You can talk to an attorney about the non-disclosure. Now, please stand next to the bailiff, follow her directions. Once you finish following her directions, you'll be free to go, and you have a blessed day. What's that?
Excuse judgment.
Okay.
I don't know, I intend something.
This is cause number 24 CCCR 0424. The case is style in the state of Texas versus Joshua Shane Quinton Alameda. Mr. Alameda, is that your full name?
Yes, sir.
Mr. Alameda, would you please raise your right hand? Mr. Alameda, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Alameda, you may put your hand down. How are you doing, Mr. Alameda? That's good. Now, Mr. Alameda, I have before me a document that is titled Judge's Explanation of Rights to Defense Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line entitled
Yes, sir.
defendant? And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Mr. Alameda, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay. Now, Mr. Alameda, your case is going to be reset. So that you'll have enough time to hire an attorney. Now, before your case is reset, I need to give you some bond conditions. Ms. Bailiff, could you hand this document to Mr. Alameda? Mr. Alameda, the bailiff is handing you a document that is titled Standard Bond Conditions in County Code at Law number 2. I'm going to go over these bond conditions with you, and it reads as follows. Following the return of criminal information in County Code at Law number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Yes, sir.
And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
No, sir. I thought that was only until the date that was signed on the restraining order.
Okay, these are bond conditions. This is a whole different document.
Okay,
Because do you understand that condition?
yes,
Now, condition number 4 and condition number 4 does not apply because that only applies in the DWI case. Your case is not a DWI case. However, hold on, is this the right one? No. No, this is the wrong. No, this is the wrong one. Hold on a minute. Give me that document back.
Yes, sir.
I got it.
The pages are mixed up. Hold on a minute. Miss, yeah, give me that back.
I'm not supposed to be drinking.
Hold on, okay, let's see. So, this one. Awesome. This is the last page. This. Get us. You can hand this back to the back page was incorrect. I corrected the back page. And Mr. Alameda, I'm going to go back over condition number 4 does not apply, but condition number 5 does apply. And condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
I can't remember the time, right?
Not while you're on bond. Do you understand that condition?
Yes, sir, I just don't understand how that pertains to anything at all.
Oh, this is an assault family violence case,
Yeah,
and the court has a obligation to protect the defendant, the victim and the public.
yeah, I
And
moved-
so therefore, that's the order of the court.
yes, sir, I moved 5 states away. I've come from Utah.
Okay,
Uh,
okay, now do you understand that condition?
yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked. If your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County jail. All
So
right,
I'm not allowed to be out of state.
that's not a violation of your bond. You gotta talk to your bondsman about that.
They know where I'm at.
Okay, well, that's not one of these conditions.
No,
Okay.
I'm just double checking,
Yeah.
sir.
Yeah, you just have to talk to your bondsman. Yeah, I don't know if that's one of his conditions, one of your conditions of your bail bonds. Okay,
Okay.
all right, so your case is gonna be reset to give you an opportunity to hire an attorney. Our court coordinator is gonna reset your case. Once your case is reset, you're free to go and you have a blessed day.
Yes,
All
sir.
right, have a seat in that first chair on the wall. Celso Cruz. Ms. Cruz? Is this Celso? Cruz, Mr. Cruz. Okay, this is cause. What?
Wanted to know if we can have some more time.
November the 8th. How much more time do you need?
It cost me like $2,500.
Okay.
To get down.
Okay, but how much more time do you need?
Probably another month if possible.
Okay, give him another month. Okay, this is cause number 24CCCR 0400. Case and style of state of Texas versus Celso Humberto Cruz. Ask Mr. Cruz if that's his full name.
Lima. Alberto Cruz Lima.
Humberto Cruz Lima. Okay. Okay, Humberto Cruz Lima.
Yes.
Now, Ms. Araji is the translator. Ms. Araji, would you please raise your right hand? You swear to interpret Spanish to English and English to Spanish to help you God?
Yes, Judge.
Okay. Now, Ms. Araji, how are you doing?
Good, Judge. Thank you for
Yes.
asking yourself.
I'm doing fine. Thank you for asking me. Now, I see here that Mr. Cruz has a document that's titled Judge's Explanation of Rights of Defendants Without Attorney. Did I swear him in? Oh, I need to swear him in. Mr. Cruz, Mr. Cruz Lima, do you swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Judge.
Okay, you tell him to put his hand down. Now I have Okay, I have before me a document that's titled Judge's Explanation of Rights of Defendants Without Attorney. Ask Mr. Lima, Cruz Lima, if you recognize this document. You recognize? Ask him if this is a signature on the line that says defendant and it,
Yes, Judge.
and all these is initials on the line that say he would like to apply for court appointed attorney. Also,
Yes,
it
Judge.
does, Now, there's another document here. Now, this document was in English and this document is in Spanish. Ask Mr. Lima if he recognized this document.
Este documento que llenaste.
This
Yes,
is,
Judge.
okay, this is affidavit of indigence. And ask Mr. Lima, approves Lima, if this is signature on the line that is titled defendant.
Y esa es su firma ahí. Yes, Judge.
Now, ask Mr. Cruz Lima, before he signed and initialed this document in English, if you went over this document, went up with him in Spanish.
Antes de firmar ese documento que está ahí, sí te explico lo que estabas firmando. De la corte de apuntar un abogado. Yes, Judge.
And now, this document, which is in Spanish, now ask him if he understood everything that is in both of these documents.
Y antes de firmar los dos documentos, ¿sí entendiste lo que firmaste? Yes, Judge.
And is everything in these documents true and correct to the best of his knowledge?
Y todo que pusiste en el de verdad.
Yes. Okay. Okay, tell Mr. Cruz Lima that I read his answers. Based on his answers, you meet the eligibility requirements for the appointment of attorney, and his attorney that's appointed is Charles Warhol.
Dice que se le los papeles y quiero la apuntar en el abogado del corte y el abogado de la Charlie Williams. Y él sí habla español.
Okay, and just tell him that our court coordinator will give him the information to contact Mr. Ross. Mr. Ross will be given information to contact him. Once he gets that information, he's free to go, and tell him he can have a blessed day.
Dice que le va a hacer la atención y el funcionario de la verdad. Y que le va a dar el sitio y con esta votación y que decide que
Tell him have a seat, and we're going to do the next guy.
Sí. Ahí
Okay. Melchor Mushan Zanti.
Ahí, sí.
Okay. Ask him if his full name is Melchor Mushan Zanti.
Eso es su nombre completo. Yes, Judge.
Okay. Ask him to raise his right hand. Okay, Mr. Mushan Zanti, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, Judge.
Tell him to put his hand down. Ask him, Mr. Mushan Zanti, how he's doing?
¿Cómo estás?
You
Good.
good? Okay, that's good. Now, Mr. Mushan Janti, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Asks Mr. Mushan Janti if he recognizes this document.
Pues ese documento confirma. Yes, Judge.
And is this his signature on the line that's titled defendant?
Yes, es su firma ahí. Yes,
And are
Judge.
these initials on the line that state he'd like to apply for court-appointed attorney?
También sus menciones diciendo que quieres aplicar para un abogado. Yes,
And I also have a document, it's affidavit of indigence. Ask him if he recognizes this document.
¿te puedes ver el documento que dice? Yes, Judge.
And ask him if this is his signature on the line that's titled defendant.
Y ese es su firma completo ahí. Yes, Judge.
Now, Mr. Mushan Zanti, before you sign and initial these documents, did Mr. Raji go over these documents with you in Spanish?
¿Te firmas el documento sí te explicó todo en español? Para lo que estabas firmando. Yes, Judge.
And ask him if he understood everything that you went on.
¿Te entendiste lo que firmaste para un abogado? Yes, Judge.
And is everything in these documents true and correct to the best of his knowledge? Okay.
Judge.
Mr. Mushan Zanti, read your answers, and you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that's appointed to represent you is Attorney Charlie Ross.
Dice que él se le quedó y le estaba
Here, bro.
Okay. Now, before I give him that information, I need to give him some bond conditions.
Okay.
Mr.
Antes de dar la información del abogado, tiene que tener unas condiciones con ustedes.
Okay, now, Mr. Musan Zanti, I'm gonna read this document. And the document states that, this is standard bond conditions in County Code at Law number 2.
Siendo las condiciones del
And you might want to read along. Following the return of a criminal information in County Code at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named here and are ordered subject to the additional conditions.
sino que usted tiene que hacer las condiciones del bond a la municipal.
Number 1,
Número uno,
the defendant shall commit no offense against the laws of this state, any other state, or of the United States.
dice que no se puede hacer el juicio en este caso el juzgado en los Estados Unidos.
Do you understand that?
Que entiende cosa. Es decir, que no puedes hacer el defensor. Yes, Judge.
Number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body.
Okay. Usted tiene que hacer el examen que ellos quieren. Entonces, y si hay una vez que no pasa, se le pueden quitar el bond. Que si entiendes eso.
Okay, let me see his bond, and I need to strike through a word. There we go. Okay, now condition number 3 does not apply, but condition number 4 does apply.
Okay. And you will proceed.
And condition number 4 states, a defendant whose information charges any offense listed under section 49.04 through 49.06 of the Penal Code, and that's the section for DWI cases. Shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after today.
Okay, que tienes que comprar uno para el carro. Okay, he said that he doesn't have a car, but he has a machine that he uses for himself.
Okay, well, that's, okay, now if he gets a car, any car that he own or drive or operate, even if he doesn't own it, it has to have that device on it.
Y dice que se va a manejar, si no es su carro o otro carro, sino que tenga una máquina, ¿ok? Que sí entiendes.
So he can't drive a car that does not have that device on it.
Correct, he understands that.
Okay. Now, condition number 5, the vendor shall obtain, maintain, pay for, and have no violations with the ignition interlock device. And I guess he has the mobile breath device. Any violations will be grounds for revocation. Now, he needs to provide proof that he has that machine to the court.
Okay.
Within 3 days, they can give him a fax number, where he could send the paperwork to, or they could give him an email, or he could bring it in person to this court.
Okay, dice pues, que tienes que traer como un recibo o la máquina para enseñarle que ya tienes el Ok, pues tienes que traerlo en máquina o un recibo diciendo lo mismo antes de que lo ordenes, ¿ok? Sí, como hoy o mañana. Ok, lo tengo que traer. Sí, mañana. Sí.
Okay. Now, the defendant, he must attend AA meetings 3 times a week and provide proof to the court.
Y luego tienes que crear la recibo diciendo que ya completaste los clases.
And I have a list of places he can go. I'm sure there's one on here where they do it in Spanish.
Dice que hay una lista donde puedes ir y hay uno en español.
And this is a sheet he need to bring every time that he goes,
Y ese es el papel que tienes que ponerle los 3 veces.
that they will sign it. And he needs to bring this sheet back every time he comes to court.
Y tienes que regresar con esto al tribunal de justicia, ¿ok?
Okay. He understands?
Sí, muy bien. Esto cuando vayas a la clase vas a poner el como la tiempo a los que se precisan del recado. Ya, mira, tienes que buscar un aquí, donde quieres ir, ¿ok? Y luego cuando vayas a la clase, tienes que poner el tiempo y la fecha y la maestra ahí tiene que firmar aquí, ¿ok? Cada vez, pero tienes que hacer 3 veces por semana. Y luego enseñarle para... You want him to show it to you every week? Or just
No, when he comes back to court.
Okay, nomás tienes que traerlo cuando vienes de la fiesta, ¿ok? Sí, lo van a decir. Sí.
Okay. And that's it. You can,
Es porque-
she'll reset his case.
Eso sí. Ok, ellos te van a dar otra fecha, ¿ok?
Okay, thank you, Mr. Raji.
Yes, sir.
Okay, Cordell Colbert.
I just wanted to advise you, Judge, that
Oh, hold on. Okay, this is cause number 24 CCCR 0154 cases. Let me strike that. This is cause number 24 CCCR 0380 cases styled the state of Texas versus Cordell Colbert or Colbert. Mr. Colbert, is that your full name?
Yes, sir.
Mr. Colbert, would you please raise your right hand? Mr. Colbert, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Colbert, you may put your hand down. How are you doing, Mr. Colbert? That's good. Mr. Colbert, I have before me a document that is titled Judge's Explanation of Rights of Defense Without Attorney. You recognize this document?
Yeah.
And this your signature on the line is titled defendant? And are these your initials on the line that state you'd like to
Yes, sir.
have your case reset to hire your attorney?
Yes, sir.
Now, Mr. Colbert, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Colbert, our court coordinator is gonna reset your case, but before she resets your case, I need to give you some bond conditions. Ms. Bailey, you have, Ms. Mosby, could you hand these bond conditions to the defendants? Okay, Mr. Colbert. The bailiff has just handed you a document that is titled Standard Bond Conditions in County Court Law Number 2. Do you see that title?
Yes, sir.
And I'm going to go over these bond conditions which you states that following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and a test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, so like, my bondsman gonna be drug tested?
No, the court. We will. Okay, so if the court asks you for a blood test, to be drug tested, if you test positive, that's a violation. Or if you refuse to take the test, that's a violation. All right. And condition number 3 and 4 does not apply. Condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay, now, Mr. Colbert, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
All right, please have a seat in that first chair and wait for your name to be called. Once your name is called, you're free to go and you have a blessed day. Thank you, Mr. Rogers. Next case is cause number 24-CCCR 0886. Cause number of the case is styled the state of Texas versus Trevor Elliott. Mr. Elliott, your full name is Trevor Wayne Elliott.
Yes, sir.
Mr. Elliott, when you please raise your right hand, Mr. Elliott, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Elliott, I have, well, first of all, Mr. Elliott, how are you doing?
Good, about yourself?
I'm doing fine, thanks for asking. Mr. Elliott, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Okay, Mr. Elliott, before you signed and initialed these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Elliott, I read your answers. Your case is going to be reset. Our court coordinator is going to reset your case. Once she's reset your case, you're free to go and you have a blessed day. Please have a seat in that third chair on the wall. Here you go. Jody Buckley. Mr. Buckley, your full name is Jody Christopher Buckley Jr. Buckley, would you please raise your right hand? Mr. Buckley, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Buckley, you may put your hand down. How are you doing, Mr. Buckley? That's good, Mr. Buckley. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Mr. Buckley, before you sign and initial this document, did you read the document? Did you understand what you read? Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Buckley, your case is going to be reset by the court coordinator. Once you reset your case, you're free to go and you have a blessed day. Please have a seat in that fifth chair on the wall and wait for your name to be called.
Yes, sir.
Right there. Okay. Tyron Isidore. Mr. Isidore, your full name is Tyron Jamal Isidore.
Yes, sir.
Mr. Isidore, would you please raise your right hand? Mr. Isidore, you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Isidore, you may put your hand down. How are you doing, Mr. Isidore?
Okay.
That's good, Mr. Isidore. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials stating you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of the same document, there is a signature above the line that's titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Mr. Isidore, before you sign and initial these documents, did you read the documents? You understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Isidore, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Next case is Deontay Richard or Richard, cause number 24-CCCR 0378. Mr., do you pronounce your name Rashad or Richard?
Richard.
Richard. Now, Mr. Richard, your full name is Deontay, was Jamon Richard? Mr. Richard, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Richard, you may put your hand down. How are you doing, Mr. Richard? That's good. Mr. Richard, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this same document, there is a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
And Mr. Richard, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Richard, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that, I guess, the 6th chair. Next case. Next case is Gary Senegal, cause numbers 24CCCR 0412 and cause number 24CCCR 0413 and cause number 24CCCR 0447. Mr. Senegal, your full name is Gary Senegal III. Senegal, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Senegal, you may put your hand down. How are you doing, Mr. Senegal? I'm doing fine. Thanks for asking, Mr. Senegal. I have before me a document that is titled Jefferson County Affidavit. That's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have a document that is titled Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there's a signature above the line that is titled Defendant. Is this your signature? And Mr. Senegal, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Senegal, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney that will be appointed to represent you in this case as Attorney Peter Dahl. Attorney Dahl will be given information to contact you. You will also be given information to contact him. And our court coordinator will give you that information. Please have a seat in that 3rd chair on the wall. Okay. Next case. Adrian Neek Young Perry.
Yeah.
Did I pronounce your first name right?
Yes, sir.
Okay, it's Adrian Neek Shell Young Perry. Ms. Perry, would you please raise your right hand? Ms. Perry, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Perry, you may put your hand down. How are you doing, Ms. Perry?
I'm good, sir.
I'm doing fine. Thanks for asking, Ms. Perry. I have 2 documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled defendant signature, is this your signature?
Yes.
Now, Ms. Perry, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Perry, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you. You will also be given information to contact him. And the court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that full chair on the wall. Anna Lee. Okay, Miss Lee. Your full name is Anna Elizabeth Lee.
Yes.
Miss Lee, would you please raise your right hand? Miss Lee, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Miss Lee, you may put your hand down. How are you doing, Miss Lee?
Okay.
I'm doing fine. Thanks for asking. Okay, Miss Lee, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line entitled defendant?
Yes.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
Now, Miss Lee, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
And did you understand everything that you read?
Yes.
And is everything in these documents true and correct?
Yes.
To the best of your knowledge?
Yes.
Now, Miss Lee, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will give information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go. Hold on a minute. Need to read this. Okay, Now, Ms. Lee, I also have before me a document that is titled Standard Bond Conditions. Ms. Bailiff, could you hand this document to Ms. Lee? Or Ms. Lee? The document that is being handed is titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over these bond conditions with you. And it reads as follows: following the return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
And condition number 7 states that the defendant shall wear a global positioning monitoring system, that's a GPS monitor, device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that condition?
No.
Okay, you have to get a GPS monitor, ankle bracelet, okay? So do you understand that?
Yeah.
Okay, so you have 3 days to get it. If you need some locations, I think we have a sheet that we can give you. Now, if you violate any one of these conditions, your bond will be revoked. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay. Now, you can provide proof to the court either by faxing the paperwork here or by emailing, or you could show up in person and bring it to the court. All right. You can have a seat in the first chair on the wall. Randy Pouncey. Okay, this is cause number 24CCCR0764, case of style of state of Texas versus Randy Pouncey. Mr. Pouncey, is that your full name?
Yeah.
Mr. Pouncey, would you please raise your right hand? Mr. Pouncey, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Pouncey, you may put your hand down. How are you doing, Mr. Pouncey? That's good. Now, Mr. Pouncey, I have before me a document that is titled Misdemeanor Plea Admonishments.
Oh, wow.
Actually, it's titled, it's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yeah.
And is this your signature on the line that's titled Defendant?
Yeah.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials. Well, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes.
Mr. Pouncey, before you sign and initial these documents, did you read the documents?
Yeah.
Did you understand what you read?
Yeah.
And is everything in these documents true and correct to the best of your knowledge?
Is that correct?
Mr. Pouncey, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once you get that information, you're free to go and you have a blessed day. Now, Mr. Pouncey, before you leave, the bailiff need to give you some bond conditions. I'm going to go over these bond conditions with you, Mr. Pouncey. The document is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yeah.
And I'm going to go over this document with you, and it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
I understand that.
And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And now, condition number 3 does not apply to you. However, condition number 4 applies to you because your offense, which is a DWI second, is a subsequent offense listed under section 4904 through 4906 of the Texas Penal Code. And condition number 4 reads as follows. A defendant whose information charges any subsequent offense listed under section 49.04 through 49.06 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected on the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before 3 days after today. Do you understand that condition?
Yes, but I gotta sort of explain something to you. That's why I brought that paper. I just had COVID 33 times. I have another. I can't afford to buy get no self-hand carrying anything, but I gotta go back to Gap and have another major surgery. So I don't know if they want me to just sit it out after I come out of surgery and just sit it out.
Now, let me ask you this here. Now, when you were in jail, and they didn't order you to have okay, well, these are standard bond conditions by the court. It's called what it's called is a standing order. Automatically, once you go to jail and it shows that you have a DWI second, you're required to have an interlock device on any vehicle that you own or operate.
Yeah, I understand, but I don't own an operating vehicle.
Well, just listen to what you just said. And listen to what I said first. I said any vehicle that you own or operate. Then you said you don't own or operate any vehicle. So what does that mean?
They want you to have a
No.
self-held device.
Well, I'm saying that you don't need to have an interlock device on a vehicle if you don't own or operate no vehicle.
Yeah, I understand.
Okay? So you don't need to have the interlock device on if you don't own or operate it. And you said you don't own or operate a vehicle, is that correct?
That's correct.
Okay, but if you buy a vehicle
Yeah, you gotta.
or if you get into somebody, you want to go drive somewhere, that needs to be on that vehicle. Do you understand that?
Yeah, I come.
Okay, now the next condition is that the defendant shall obtain, maintain, pay for, and have no violations with the interlock ignition device, which you don't need to have because you don't own or operate a vehicle. However, it says a mobile breath device, any violations will be grounds for revocation. Now, you stated that you can't afford a mobile breath device. Okay, my question is, have you went to a place and inquired how much a mobile breath device costs?
No, no, I have to call on 1 to 12, or two of them, they like, well, one.
Let me ask you this here. Why would you call about a mobile breath device if nobody ordered you to get a mobile breath device?
Because my cousin had a DWI, he said they might try to.
So that's your cousin. So
Right.
your cousin had a DWI and you said they might try to give you one. So you decided, well, okay, I got a DWI second. Let me call down there and find out how much it costs.
Yeah.
Okay, now I'll tell you what. You ordered to have a mobile breath device. You need to go down there, and if you cannot, you're gonna have to bring that paperwork back to the court, and we're gonna have a hearing. Okay?
Mhm.
To determine whether or not you can or cannot afford uh to get one. And there's some other things that we may be able to do. You understand that?
Yes, sir.
All right. Now, now, condition number 6. Defendant must attend AANA meetings 3 times a week and provide proof to the court. Do you understand that?
Yeah, I understand.
Okay, now I have with me a sign-in sheet that the bailiff is going to give you. Every time you go to AANA meetings, a sponsor is gonna sign to verify that you've been going to the meeting. You think that's funny?
No.
Oh, yeah, you laughing. Okay. Now, also, I have locations. There's a number of locations in the Jefferson County area that you can go to at various different times. So you pick one out that's convenient for you. You need to go 3 times a week. And when you come back to court, every time you come back to court, you need to have this sheet. It's going to be signed. We're going to verify that you're attending. And if you do that, then you'll be in compliance with this order. Do you understand?
Yes, can I ask you another question?
Yes.
Okay, well, can you, with the court appointed attorney and everything, if you wanted to sit it out, how long did it take you to sit out in jail?
Talk to your lawyer.
Yeah.
Yeah, I can't
Yeah.
talk to you about this. Just talk. All right. Just talk to your lawyer. Okay? Just have a seat. Now, Mr. Pouncey, oh, did we give you that? Okay, yeah. We gave you your paperwork. Is that correct? Yeah. Okay. All right. Here you go. Get it. Did I give you this one back? Did I give her that one back? I think she already took care of him, Colbert.
So, we're doing the training.
Oh, they dismiss him? Oh, okay. A waiver on what? Yeah, that's right. She right. Yeah, just get him to, she is right. Yes. Okay. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 24 CCCR 0380. Let me back that up. It's clause number 24 CCCR 0380. The case is styled the state of Texas versus Cordell Jamal Colbert. Mr. Colbert, would you please raise your right hand? Mr. Colbert, do you swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Colbert, you may put your hand down. Again, Mr. Colbert, how are you doing? That's good. And Mr. Colbert, I have before me, now, Mr. Colbert, you have a right to have a record of this case. That means you have a right to have a court reporter type down or dictate everything that's being said. You also have a right to waive or give up your right to have a court reporter in this case. Do you waive or give up your right? Okay, Mr. Colbert, I have before me 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendants?
Yes, sir.
And are these your initials on the line that state you like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
Now, Mr. Colbert, before you sign and initial these documents, did you read the documents?
Yes.
And you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Colbert, I also have before me a document that is titled Motion to Forfeit. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And also I have before me, now, before you signed sign this document, did you read this document?
Yes,
Did you understand what you read?
yes, sir.
Is everything in this document true and correct to the best of your knowledge? Now, Mr. Colbert, you want the court to grant this motion to forfeit the weapon to the Needham Police Department?
Yes, sir.
Okay, Mr. Colbert, I'm signing this motion forfeiting the weapon to the Needham Police Department. Now, Mr. Colbert. I also have before me, Mr. Colbert, on my computer, a document that is titled Motion to Dismiss. Is that correct, State?
That's correct, Your Honor.
Now, Mr. Colbert, the state has filed a motion to dismiss in this case. And I'm going to sign this motion because you forfeited the weapon as part of the plea bargain, in this case to the Needham Police Department. And I'm going to sign this motion, and Mr. Colbert, once I sign this motion, you'll be able to get a copy of this motion. Once you get a copy of this motion, you'll be free to go. And you have a blessed day. Please have a seat on that 3rd chair on the wall.
State excuse, Your Honor.
Yes,
Buckley?
you excuse.
Thank you, Judge.
Yeah. Okay, I hadn't signed it yet. I want to make sure. Now, Mr. Brown, your full name is Derek Markel Brown. Mr. Brown, would you please raise your right hand? Mr. Brown, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Brown, you may put your hand down. How are you doing, Mr. Brown? I'm doing fine. Thanks for asking. Now, Mr. Brown, I have before me two documents. The first document is titled, how did you have, you didn't need a waiver. Okay, okay. Now, that has to be sure. Mr. Brown, I have before me a document that is titled, Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a set of initials where there's a signature above the line that is titled defendant's signature. You recognize this is this your signature?
Yes, sir.
Mr. Brown, before you signed and initial these documents, did you read the documents?
No.
Did you understand what you read?
No.
And is everything in these documents true and correct
Sir,
to the best of your knowledge? Okay, Mr. Brown, I read your answers based on the answers. You meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that's appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you. You will be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall. You are. I can't say anything about your case.
Hey, you gotta do that like every week.
3 times a week. Huh?
How long they gonna reset it? You feel like what, 1% or 3 weeks?
She'll let you know when when your court date is.
You also tell me about, to bring that other paperwork when I can't get the already got, just bring this paper that I already have.
No, you go back there and get some recent paperwork to show that,
And I go back to the doctor on the 7th. I gotta go have surgery on the 7th, October 7th.
yeah, okay, I thought the paperwork you was talking about was the paperwork
No.
about the, mobile
I
device.
mean, I can go, get up there. I don't have a vehicle, I'm gonna have to ask somebody to take me.
Well,
Only thing I'm gonna have is mostly my medical paperwork about how I can't work anymore.
Okay, no, but I'm just saying you need to go get that paperwork from the mobile, from the people that provide that, mobile device. The paperwork telling you how much it costs and all of that stuff.
Okay, I'll bring you that. And then,
That's why I told him, I said, listen, here you go.
This is your court appointment, Mr. Thomas Williams, court date is gonna be November the 8th at 9 a.m. And this is the terms of commission down. Okay?
you can give me the interlocking, whatever those people do.
No, they have that mobile device, the interlock, and within that, court will be in recess for trial for 1:30.